My name is Frank Upham. I'm a faculty advisor at the U.S. Asia Law Institute. And today's webinar is about a topic which I think many of us anticipated for a long time and then thought would never come. And I'm talking personally now. The topic is an overloaded Chinese court system. Why is it overloaded? Well, because China changed its administrative litigation law, making it easier for people whose land was taken by eminent domain to sue in administrative lawsuits to get more compensation, or I suppose we'll find this out in principle, to perhaps stop the eminent domain. That's one of the questions I will have for our two speakers. But first, I want to announce next week's program. It is entitled Trade Links, New Rules for a New World. It will be on Wednesday, April 27th at 12 p.m. Eastern Time, so during the middle of the day in New York time. And featuring James Backus, is a founding member and former chairperson of the appellate body of the World Trade Organization. He will talk about a new book in which he argues that the devastating global economic toll of the COVID pandemic will dramatically change and has dramatically illustrated the World Trade Organization's weaknesses and dramatically illustrated the need to update its rules and in order to confront future pandemics and the inevitable impact of climate change. Again, that will be next Wednesday, April 27th at noon US Eastern Time, New York time. Please visit our website to learn more about this webinar. Our faculty director, Professor Jose Alvarez, will moderate. We hope to see you there. Let me now introduce the program and the speakers. As I mentioned, in 2015, there was a change in China's administrative litigation law, and this change caused a huge growth in the court's workload. I'm sorry, you can see on the screen now a link to next week's program. The workload focuses on property expropriation. Those of you who are interested in property or China or Chinese courts will know, or maybe the lack of Chinese courts sometimes, will know that the taking of land for China's growing urban areas has been a consistent social and legal problem for the last 30 or so or more years. Speaking today will be Professor Shitong Qiao of Duke School of Law. And Professor Qiao is a property scholar, teaches American property law at Duke, but has also written about property in China, including the phenomenon known as small property rights in Shenzhen. And joining Professor Qiao is Professor Chaoqun Zhan, who is not a law professor, probably to his benefit, is an economist at Lingnan College and Yat-sen University. He will give an economist counterpoint to Professor Qiao's legal perspective. One of the things that is in the paper and will come out is the surprising result of Professor Zhan and Professor Qiao's research, that Chinese courts began to find for plaintiffs' claims more than the government as the surge of cases came on. Now, I hand it over to Professor Qiao first, and then Professor Zhan later. We will have a discussion and of course, a Q&A. Thank you very much for attending. Shitong, take it away.
Okay, so thank you, Professor Upham, and also thanks, Catherine, and also everybody at USALI for the invitation. It's great to be here. So also very glad to have my co-author, Professor Zhan Chaoqun here to present this research together, which is still a work in progress. So we do truly appreciate and welcome your comments and questions later after the presentation. So I'll do the first 10 minutes and Chaoqun will do the second part, probably the more challenging part. So firstly, let me just talk a little bit about the motivations of this project. The first motivation, of course, is what Professor Frank Upham has said about protection of property rights in China, right? This is related to the broader literature in law and economics or development economics or just law and development, which generally argues that judicial protection of property rights is quite important for economic development. Okay? So that's one. And in the Chinese background, I think is an even more interesting issue. So at least 5 years ago, right, when we started this project, we didn't really have much data, right, about whether Chinese courts really play a role in protecting property rights, right? So back then, here, let me quote Professor Upham, right? In the 2015 essay, he wrote that the notion that a Chinese court would protect private property rights from the state is more likely a cruel joke than an effective strategy.
I think we'll go straight to Q&A now, Shitong. I'm sorry. Go ahead. As the audience will see, Shitong and I are very close friends and have talked about this issue many times.
Yeah,
I will be quiet now.
We're talking about it a lot. So I guess so that's really a factual question. That's what we want to find out today. But I guess a critique of the literature, I mean, the ongoing research is that both about China and also about judicial studies in the US or in the developing world more generally, that there has been enough talk about, it can never be enough, but there has been lots of talk about judicial independence, right? But not much about resource constraints, right? The resource constraints courts or judges are facing in the developing world, right? Particularly, I'm going to talk about judicial overload, basically to say there are too many cases for judges to handle. That could be an equally important factor that might impact judges' decisions, right? Equally important to, for example, judicial independence or judicial non-independence. So that's the first motivation of this project. The second one is more from a comparative context. There have been lots of research about the so-called the workload crisis in the US judiciary, right? For example, Judge Richard Posner and his co-authors, they have written about this issue. And more specifically, Columbia Law professor Bert Huang has a famous article at Harvard Law Review in 2007-11 talking about how federal circular courts flooded with cases, right, actually were less likely to overrule district court decisions compared to their sister circuit courts, right? And the rationale is that they are not supposed to do that just because there has been too much workload, right? And economists have also done that. The 2018 article investigated whether bankruptcy courts in the US adjudicated cases differently in response to an explosive increase in workload resulted from a bankruptcy legal reform in 2005. So in the US background, right, what I say is that there have been studies, right, about commercial courts, bankruptcy courts, right? But there have been no empirical studies on the impact of workload, even in the US context, right, on administrative litigation, including expropriation litigation. So that's the second motivation from a comparative context. The third one, we're coming closer to China, right? Third motivation is really about the judicial workload crisis in developing countries. So I did a little bit of literature review, like in India, excessive workload has inhibited the Indian Supreme Court from conducting meaningful judicial review, right? And there is also empirical research done by leading economists published in leading econ journals, arguing that decreased workload in lower courts in India actually could inspire more effective contract enforcement and greater investment. Right? In South Africa, a recent article reveals that judges are literally suffering under the stress, mentally suffering under the stress of an inordinately heavy workload. In Brazil, there's a 2016 Quarterly Journal Economics article also talked about how less congested courts actually better enforce bankruptcy law protecting creditors' rights. So all this literature, right, basically support an intuition or consensus from labor economics. The idea is that overwork, right, or more workload diminishes quality of output, right? Less work improves the quality of output. So that's where the research stands. So a question for me, the legal scholar is, since there is this ongoing workload crisis all over the world, right? So how do courts in the world, right, in the US, in developing countries, in China, how do they respond to increased workload? Or how do we solve such a problem if we think that increased workload has diminished the quality of judicial decision making, right? One possibility, right, if we follow market or labor economics, we can argue that we should increase supply of judges, basically more judges, right? But that's unlikely in the US, in India, Brazil, or in China. Right? And what makes it worse is that if we talk about authoritarian regimes, that's, China is an authoritarian country, right? If we talk about authoritarian regimes, which features authoritarian control over courts, it could make things even more complicated. So we don't have any empirical study, but just based on theory, we can talk about it a little bit, right? First thing is that there has been this emerging and fascinating literature on the so-called authoritarian legality, right? The point is that authoritarian regimes, they actually have realized that a well-functioning courts, right, can be of use of authoritarian regimes, right? Can enhance its legitimacy, right? And can resolve disputes more effectively, etc. All serves the interest of the authoritarian regimes. But one thing I think for this kind of literature that has been neglected in this kind of literature is that if courts are becoming more important in authoritarian regimes, that also means there is going to be an increasing workload for courts in such countries, right? And how are courts in authoritarian regimes going to handle the increasing workload? This literature has not addressed this specific issue. Another literature about authoritarianism or authoritarian legality, right? Actually have found out that not empirical statistical study, but case studies of, for example, Turkey and Hungary. They found that autocrats in the two countries have intentionally increased the workload of constitutional courts to bury judges with tedious, insignificant cases that will keep them from sufficiently scrutinizing the behavior of government actors and their potential constitutional encroachments. So that's to say, this literature, right, from based on the constitutional courts in Turkey and Hungary, also supported the idea that too much work diminishes the quality of judicial functioning, right? So that's, again, how could it be wrong, right? So my own thinking, right, about this question of how could courts, generally speaking, not only in authoritarian regimes, how could they respond to increased workloads, right? More judges, unlikely. But there's a possibility, I think, has not been addressed sufficiently, is that judges, they might or they can adapt. Right? So, and the judges and authoritarian regimes, they are more likely to adapt than judges in liberal democracies, because they are, they are facing immediate consequences, right? If work had been delayed, if they cannot finish their cases on time, compared to judges in liberal democracies, they probably don't have that kind of immediate pressure. So that's just a hypothesis, right? A theoretical thinking, but we don't have much empirical study so far. That's where our project kicks in, right? So our research questions specifically is, does an increase in judicial workload impact judicial review of eminent domain or expropriation in China, right? More specifically, does increased workload impact property rights holders' chance of winning in administrative litigation of expropriation? And if yes, right, either right positively or negatively impact. If yes, what is the mechanism, right? How judges adapt, right? Does that have an impact on the mechanism of judicial decision making? So first thing, data, right? This is, of course, what everybody now is using, the Chinese judgment online, right? We also use data from Chinese yearbook of law, right, to find out basically the number of filed cases in China from 2014 to 2017. And data collection strategy, we focus on the high people's courts for various reasons. One reason is that most of the time, right, such administrative litigation, they end at the high people's courts, right? Only a small portion of them really goes to the Supreme People's Courts, including the circuit courts, right? That's one. But secondly, also it's also due to our concern about data. So high people's courts, generally speaking, they are more rule-based and also have less incentives to not report cases, right? So that's another concern. So generally speaking, we also have interviewed judges, not many of them, only 4 of them from courts in Beijing, Guangdong, and Shanghai, basically to confirm, firstly, whether the expropriation decisions are too sensitive to upload or not, right? The answer is no. The second one to confirm our data is that there is a report on judicial transparency, and more specifically about the the online publication of judicial decisions, basically the Chinese judgment online website done by the Chinese Academy of Social Science. I think this report was published in 2019, right? Report also confirms our argument that high people's courts are performing better than lower courts in reporting, in uploading their decisions. So overall, studying China, one challenge is always about data. So at this moment, I have done this project for 3 to 4 years, right? Is there missing data? I have to say Probably, but is our data biased based on the questions we are investigating, the winning rate, and also the judicial decision making, the mechanism, right? How judges choose among different legal doctrines. We don't think the missing data is going, or our data is going to be biased in those dimensions. So that's the data. And the research design, as Professor Frank Upham has said earlier, we use the 2015 revision. That's the first revision, a comprehensive revision to China's administrative litigation since 1989. We use that law as an exogenous shock, right, to explore the impact of workload on judicial decision making in China. There are many different parts of this revision, but for our purpose, the revision requires Chinese courts to accept cases without a preliminary screening, as far as there is a plausible cause, right? Basically changing to the so-called 立案登记制, right? Basically, if you have a case, you go to court, they are supposed to accept it. So that's different from before. The courts actually had many reasons, excuses, right, of not accepting your cases. So the result of this reform is that it has significantly increased the workload of judges. And there have been lots of reports by this, but our data will show you, right, the scope or the scale of the workload exposure. So I'll just give you an overview of our results, right? First one is the surprising, or maybe not that surprising result, is that property rights holders were more likely to win their cases in courts with a larger increase in workload compared with their counterparts in courts with a smaller increase in workload. So what's the mechanism? Firstly, there are three grounds to review an expropriation decision, right? Administrative procedures, right? For example, requirements of public hearing and also requirements of notice to property rights holders, etc. Right? Those are like lots of administrative procedures to control how local governments in China should exercise their power of eminent domain. Right? The second one is this requirement of public interest. Right? A project should be for public interest, but how to define it? That's decades. That's a question scholars have debated for decades. Right? The third one is just compensation, basically to say whether how much compensation the government should give to a property rights holder, right, for taking his property. So the point I want to make here is that administrative procedures, they provide clear rules for judges to decide a case, right? Whereas the meaning of public interest and just compensation, they are ambiguous, right, and hard to decide. So that's the first point, right? The three grounds of reviewing expropriation or eminent domain decision. The second one is that actually based on my previous research, which has shown that Chinese judges clearly prefer administrative procedures to ambiguous standards of public interest and just compensation in adjudicating expropriation disputes. So those are the previous background, right? And our theory here is that clear rules, i.e. administrative procedures of eminent domain, they also could save time in judicial decision making, right? So whether the government in exercising its expropriation power, right, has made a procedural mistakes, you know, whether there's a public hearing or not, that's a yes or no question. So that's, in other words, if we can quote, for example, Judge Richard Posner, right? The administrative procedures or some legal doctrines, they are big time savers, right? So, and lastly, right? So if judges are under, immense time pressure, they might be more likely to uphold arguments focusing on clear rules such as administrative procedures or eminent domain. right? Then focusing on, oh, what's exactly public interest, or what's exactly just the composition. So their purpose is to use such rules, such doctrines to save time. But in return, such doctrines, exactly because they are clear, right? Once you choose them, that's a yes or no question. That's not much discretion, right? So these clear rules, in turn, they could limit judicial discretion. And in an authoritarian regime, right, although we can understand, judicial discretion is quite prone to arbitrary political influence, particularly from the local level. So we think that could explain the surprising result that workload actually leads to like a higher winning rate for property rights holders in China. But I'll leave the more challenging work, the specific models, the numbers to my co-author, Professor Zhan Chaoqun, to explain. So Chaoqun, the floor is yours.
Okay, thank you. So I will first give a brief discussion on the reform that we use to identify the causal effects. So here the graph presents the total number of judicial workload of administrative litigations. So it's clear that after the law revision, the administrative litigation cases explode, right? And the expropriation case is one type of the administrative case, but it only accounts for like 7% of administrative cases during 14 to 17 in our sample. So during that time, when they adjudicated expropriation cases, the workload pressure mainly came from other administrative litigations. So these pressure are not directly correlated with the features of the expropriation cases. So we use the increase of the total administrative litigations to measure the workload pressure faced by judges when they adjudicate the expropriation cases to identify the effect of increased workloads on the judicial results. Next, please. So we classify courts into two groups. The first group belongs to, the first group are courts with larger increases in all administrative cases workloads, where the workload is measured by the number of administrative cases adjudicated per judge per month in each period. So if the court experienced a larger increase of these total administrative cases workloads before and after the law revision, and we classified into the treatment group, which we denoted with a dummy variable HC equals to 1. And the rest are the control variables. And this map has, with the darker sides, denotes those courts with larger increases in workloads, and the rest are the control group with courses face smaller increases of workload. So it's clear that, first of all, it's kind of dispersed, that it is not directly determined by the economic development level. So you can see that Shanghai, which is a very highly developed city, but it belongs to the control group. But the Guangdong province, it belongs to the treatment group. And there are also very underdeveloped provinces like Heilongjiang, Jilin, they belong to the treatment group, but also other underdeveloped provinces in the Western China, they all belong to the control group. So it seems that we cannot find a very clear pattern how they're distributed. So we think it's kind of quasi natural experiment. So next, please. So based on this classification, we use the difference in difference methodology to identify the causal effect. Here, the win CT means that the winning rates of the is a dummy indicating whether the whether the property holders win the cases. And HC is defined previously as the treatment group, which are courts that face a higher increase in workload. Post-T denotes the years after the reform. So here the core coefficient is beta 1. To identify beta 1, we also control for other attributes that might affect the education results, including some provincial characteristics, such as the development level proxied by the GDP, and also the legal environment index for each province to proxy for the total development level of the legal system in each province. And we also control for a lot of other characteristics. For example, the government level, whether the government hired a legal representative, also plaintiff characteristics such as her identity, the number of plaintiffs, and whether they hired a legal representative, and also some property characteristics, project characteristics, and other characteristics associated with the case. Besides that, we also control for the fixed effects at province level to control for all time invariant characteristics of each court. Next. So beta 1 is the coefficient that we want to estimate. It measures the difference between the changes in the winning rates in courts with larger workload increases and the corresponding changes in courts with smaller workload increase. So to put it simply, it measures the effect of workload increase on the winning rates of the property right holders. So this is what beta 1 means. Now we look at the baseline results. Use one sentence to summarize it. We find that the increase of workloads will induce the increased winning rate of the property right holders. We look at column 1, which reports the coefficients. Here, the coefficient in the red rectangle is the estimated beta 1. It shows that the winning rate of the property right holder is significantly higher in the busier courts after the reform compared to those in the less busier courts after the reform. So this shows that the increase of workload has increased the winning rates of the property right holder. Okay, next. So the validity of the difference in difference methodology relies on the assumption that the control and treatment group are comparable. So to validate this assumption, or to see that whether a concern of our identification is that those courts, they screen cases differently before the law revision, right? So we show whether their education results are different before the law revision. So here we plot the coefficients for each half year, which compares the same differences between the treatment group and control group in the winning rate of the property right holder. With here the data is the estimates, while the line is the 19.5 significance interval, confidence interval. So we can see that before the reform, we cannot see any significant differences in the winning rate of property right holders between courts in treatment groups, in the treatment group, and courts in the control group. So we think that they were comparable in the pre-reform period. And another takeaway that courts, they started to diverge in the winning rate after the reform between the treatment group and control group. So the treatment group significantly started to have a larger probability of winning rates of the property right holders after the reform. This confirms our findings. So basically, we find that the increase of workloads has increased the winning rates of the property right holders. But why? Then that goes back to our previous motivation that it might be because those judges, they can adapt to the workload. So we refer back to the judicial process, not the judicial results. We refer to the judicial process to see how the workloads might affect the judicial process, which in turn affect the judicial results. Next, please. So here we focus on the three arguments we have previously described. The first is the procedure mistake. The second is the fair compensation. The third is the public interest arguments. So we find that in the rectangle part, the busier courts, they are more likely to uphold the argument of procedure mistakes if these argument is raised, but not the effect is not in the fair compensation. Also, although we find a significant effect on the public interests, but there are only a dozen of cases that were upheld by the courts. So these are not important. So basically, we find that the increase in workloads will induce courts to more likely to uphold the procedure mistake arguments. And once in our data, upholding the PM argument will lead to like 93 or 94% of winning rates. So that will increase the winning rates of the property right holders. So this is the mechanism we find. Next, please. But there are some qualifications. In additionally, we find that the workload's positive effect on judicial review only exists when defendants are county-level governments or below. And in those cases where the defendants are above the county level, or when the administrative head is present in court proceedings, the impacts becomes negative, becomes the opposite. And also, we also find that when the expropriation decision of a lower government has been reconsidered and reconfirmed by a higher level of government, that information is loaned to the court. And that will also diminishes the positive impact of the workload. So overall, we think that also the workload increase have increased the winning rates of the property right holders, but the power, whether it is by a higher authority or simply when the government is more insistent in exercising expropriation power, the power eventually will override law and defining the limits of the judicial review. Next. So here are the results supporting the previously discussed qualifications. Next, please. So in conclusion, we first find that that increased judicial workload improves judicial protection of property rights against government expropriation. And we explore the mechanism of judicial decision-making to understand these counterintuitive results and discover that the judges' use of hard-edge legal doctrines, which means the administrative procedures, to save time. And this use, the use of these hard-edge legal doctrines, on the other hand, constrains the judicial discretion that mostly will favor the government. So this, by shedding light on the judicial charge of legal doctrine and underappreciated area of judicial studies, we provide evidence and refine the analysis of judging in authoritarian regimes. Thank you.
Thank you both very much. I'd like to engage in a little discussion if we can, and then we'll open it up to questions from the audience. I have one, it's not a trivial question, but it's not a macro question. Then I do have a macro question. The not macro question is on slide 2, Professor Zhan, you mentioned illegal construction. And I think it was slide 2. Mm-hmm. And that just triggered my memory of small property rights, the building of entire neighborhoods in Shenzhen and to a lesser extent other parts of China without any legal property rights at all. And as Professor Qiao pointed out, the willingness of investors to build without any legal property rights is one of the most interesting bits of data coming out of China in terms of property rights. And what I wonder is when in these cases about expropriation, is compensation given for illegally constructed buildings? So that's my narrow question. And my broader question, and this is for both of you, actually, both of these questions are for both of you, of course. As we went down the first Professor Chao's presentation, and then the different slides from Professor Zhan, my initial reaction was, this is showing increasing power of the courts, and perhaps, if not rule of law, whatever that means, which is meaningless to me, it's sort of like mother's love, who knows what it is. But rule by law, where the courts are going to enforce the law, at least when it's not political. But then, when you started in your slide on baseline results, you seem to indicate that plaintiffs only win when there's no powerful actor involved. If that's the case, is there any meaning to these results? And one possible meaning might be that I believe, and you guys should correct me if I'm wrong, that these are appellate courts, so they're at the provincial level, not the local level. So is it possible to interpret these results as simply the appellate level judges squashing the low level administrative officials who mean nothing to them and have no power over them, but not interfering with the provincial level or higher level officials who would have power over them? In other words, was my initial, I guess it's optimism. I'm not a fervent believer that China needs a legal system just like ours, whatever that is. But if it is optimism about rule of law, is that simply not shown at all by this, by these results? And it's of course a question for both of you.
Okay, thank you. I think I'll handle the two questions first and see whether Zhao Qun has anything to add. So first one, illegal constructions, whether there is compensation given to illegal constructions. The answer is yes. So there is compensation actually based on my previous work, but also in the judgments we have seen there is compensation. So the trick is this, actually, the Supreme People's Court has actually guiding cases on this. What has happened is that since 2011, right, the regulation on the expropriation of buildings and houses on the state-owned land, there has been increasing regulation of local government's eminent domain power. Right? So it has become more difficult for them to take people's property just randomly. So one thing they have found out is that if they can define buildings as illegal constructions, if they can do that, that makes taking just much more likely and also much more easily, and they'll have much more power, right? Although at the end of the day, there's still going to be negotiation, right? Bargaining, both in courts and also outside the courts. But the answer is that, yes, there is compensation, but there is going to be probably a discounted compensation, right? And these people, actually, when they sue in court, one dispute point is about the definition of illegal constructions, right? The government will say it's illegal constructions, but the property right holders will say, no, it's not illegal constructions. We have the permits. So that's what's going on, also telling us a little bit about how Chinese local governments govern, right? Basically tricking or manipulating the definition of legality or illegality. So that's the first question. The second question.
Can I ask
yeah, go ahead.
So in other words, the amount of compensation tracks the property value between legal property or big property rights and illegal property, small property rights. In just the buying and selling, the small property rights got lower market prices, big property rights, legal property got higher. So your answer essentially is that just tracks into compensation.
Yes. Yes.
Okay.
So legality is definitely a factor in deciding the amount of compensation or the price of the market transactions.
So that's good for us legal educators. You know,
yeah,
lawyers matter. Okay, or at least
it matters. It matters. Yeah, I mean to a certain degree, right? So,
right.
Yeah. So the answer your second question is like how to interpret the results, right? What is surprising or counterintuitive? So I get it. That's something I'm struggling with, but I'll try to address, right? The baseline results, because firstly, going back to your point, right? The high courts basically at the provincial level, right? We have our results, but the defendants, the governments, I think it's 83% or over 80% of the cases, right? Actually, the defendants are the county level or below, which is again consistent with reality because the county level governments, the provincial level governments, normally they don't really do expropriation or just a very small portion of it, right? So that's consistent with our data. What we show is that basically for this, yeah, you're right, this lower level officials, when they go to the provincial level court, right, is much more likely the higher court, the high court, right, could hold them accountable and also based on the rules, right, of the law. So stick to law and finding a case against such a lower level of governments, right? So, and when the level of governments goes higher, right? Or when our data shows when the administrative head, 行政首长, right, actually shows up in court. And also when there's a 行政复议, the administrative reconsideration in which a lower government's decision is actually officially confirmed by a higher government. You know, with when all those factors play in, actually, our results, it shows the opposite, right? So our result is basically diminished. So in plain words, I think eventually power overrides law, or basically defines the limits of judicial review of eminent domain in China. So those are just the facts. Should we be optimistic or should we be pessimistic? I think we just have to recognize that's the fact in China, right? That goes back to what we talked about. I mean, like at least in my earlier article, right? The regime, they want the courts to function to a certain degree because that serves the interest, right? You prefer people to fight in courts rather to fight on the street. But that preference has a limit, right? Eventually, yes, you're right. Power overrides law. So I guess depends on which friend we are going to talk to, right? Some friends will say this is China's turn towards law, right? At least for that 80% of cases, higher courts adjudicating against lower level government officials, right? That's kind of an improvement, right? And also that serves the interest of the regime. But for, again, higher governments, that's just beyond the law. So yeah, I think that's how I would respond to your question. Thank you.
Yeah, I think.
Do you have any comments?
Yeah, I think it's from the pessimistic points. It's kind of the power still overrides the law, but from the optimistic perspective, you think that a majority of those cases they have higher rates of winning rates. So we do not take a stand on which way it goes, but we show the facts.
I think we'll have a couple of questions from the chatting room. So.
Right. Oh, yes, well, we can go ahead and go into the chat. I see that Professor Alvarez, who has what the Chinese would call 特权, special rights in asking questions at a USALI webinar. Jose, do you want to go ahead and ask your question? Or can you? I don't know. I'm not quite sure the technology, or should I just read it?
I can. I guess I have been given the right to speak. I can't turn on my video, but that's fine. First, I want to congratulate both of you on puncturing at least two myths that still persist, despite my surprise out there. One is that due to some influence of Confucius, the Chinese people don't litigate. And I think yet again, you demonstrate that at least domestically, that's a lie. And I welcome that because despite what I thought was always the case, this kind of thing still appears in a lot of surprising places. The second is a myth that is entertained for as far back as the Cuban Revolution, which is that communist societies don't pay and don't actually pay any attention to private property rights, including in eminent domain. And I think you're suggesting that that is at best a complicated but much more nuanced question. But I guess I wanted to press you more on what's happened since 2014. That is, what are the numbers of eminent domain cases since that time? Has there been increase either in particular provinces over time? And not only because obviously this could have some impact on your results as a sort of a side noise question for your data, but also because I'm simply curious. That is, as the communist government solidifies its control over many aspects of Chinese society, is there more occasions for eminent domain, either regionally or otherwise? But thanks very much.
I think, thank you, Professor Alvarez, for the comments and questions. I'll answer part of it. I think Chaoqun, as economist, will also address how the change or the supply basically of dispute, whether we have controlled that in our model. My understanding is that we have controlled that. So, so do I say any evidence there are more exercise eminent domain since 2014? So what do we have? We have the number of filed cases from 2014 to 2017. And there is an increase from 2014 to 2017. We have the adjudicated decisions. There's also an increase. What we don't have is that we don't have the real number of expropriation disputes on the ground. Basically, the disputes that have not gone into court and not showing in our data. So we don't have that. But based on my just as an observer of the Chinese property regime, I'm not sure about 2014, but at least since the pandemic, I think what we can say is that there is probably, I would say overall, the trend is that the Chinese government the central government has limited the use of eminent domain, right? Both for the purpose of maintaining social stability, but also I would say for President Xi Jinping, that probably goes back to 2012 or 2014, is that his slogan is that the houses are actually to be used for living, not for sale, not for speculations. So he has been constantly trying to cool down the market, right, to deter speculations on the housing market. So if that factor actually has played in, right, I think it has, right. So the real estate market is kind of cooling down. I would say that could lead to actually less eminent domain or expropriation in China, because the primary incentive for local governments in China to expropriate land or property in the old town was actually to build more and to sell houses, because they like half of their budget, right? They have an official budget, like a revenue, the tax, and the other equally important budget or more important budget is from selling land. So, but if, right, they cannot sell that many houses anymore, right? The developers would have less incentive to buy land from the local governments, then local governments would have less incentive to take land or property from individual property rights holders. So I would say the evidence I don't have definitive evidence so far to tell you whether there has been an increase or decrease, but there are factors which I have discussed to address this question. And one thing I have been working on, I'm a busy person, so we have a friend that actually has all the data. He got the data from the one province in China, Shanxi. So he has all the data of urban renewal, rural land expropriation in the entire Shanxi province. And it's a gigantic, huge data. And we are still working on that. So if I have any results, I'll report to you. But I'll leave Chaoqun to address the question whether this data, right, the cases that expropriation, we are not able to observe. Have we controlled that in our model or not? Does that have an impact on our results or not? So Chaoqun, please.
Yeah. So basically, we are trying to control for the potential supply of those expropriation cases by controlling for the development level of each province. So basically, if a region they develop faster, they will require more industrial land, or they will have more urban rebuilds or renew projects. And that will lead to a lot of potential expropriation disputes. So we controlled for the GDP level for each province each year to control for this potential supply. Yes. And yeah.
So I would like to now move to the next question. Another person who is intimately involved, and in fact was the founder of the US Asia Law Institute, Jerry Cohen. And I will just read Jerry's question. What can you tell us about the protection of foreign property rights in these circumstances? So should Jerry worry about his chain of McDonald's in Shanghai?
Thank you, Professor Cohen. It's great to see you here, at least the comments. So I was looking for that in our data when we collect your data and also coding our data. There were interesting things. There were cases in which foreign property rights holders actually are involved. There are also cases in which actually a mosque, like an Islamic temple, right, actually involved. Or so, but those are just individual cases, like 2 or 3, not many, right? So I cannot tell you by data or by systematic data whether there has been increasing or decreasing protection of foreign property rights in these circumstances. But if I can again wear my just Chinese law hat, I would say, my intuition, I'm sure you have a much better idea than I do, is that foreign property rights actually, generally speaking, are better protected than property rights of Chinese citizens, right? So that's one thing to take into consideration. But talking about the past years, when China becomes like a more and more, I guess the implicit assumption in your question is that in the past 10 years, China has become more and more assertive and potentially more and more hostile to foreign powers, right? Whether that has changed China's attitude towards the protection of foreign property rights. Again, my guess is that it could be because I think what the Chinese leaders say, right, and also the overall international environment, that does actually have an impact on the mindset of local officials, how they treat foreign investors. We heard actually horrible stories. But I guess my baseline is still that foreign property rights holders, I think they enjoy more protection from law. than Chinese ordinary citizens. But that's, again, not supported by systematic data. Yeah.
Professor Zhan, I saw you nodding. So do you agree with Shitong in that general sentiment?
He's actually an expert on international trade, so we might have something to add. So.
Yeah. Because since Donald Trump, you have the war, the so-called trade war, and one important argument is the protection of property rights. So there is also a huge debate in economics whether the foreign firms in China are protected, their property rights have been protected. And basically we think that there is no systematic evidence of so-called stealing of property rights from the foreign firms or things like that, because you cannot distinguish whether it is a spillover of technology or it is kind of a stealing of the property rights.
Yeah, and also I can add, I guess, one anecdote. Our quote and unquote common rights in China, including actually some of my older classmates who are now local government officials, they are still very actively or eager to find investment. I mean, to go to their cities, like particular like foreign investment. So I would say that direction, at least until now, has not changed. But China is complicated. So what do we know? We can think about Elon Musk, right? His big investment in Shanghai, right? I mean, that happened just in the past 10 years. But in the future, I guess we're just in the period of uncertainty.
So would it be correct to say the following regarding foreign property rights? And I should say we have a question waiting from a judge, a Chinese judge, and so that we'll go to that next. But first, I'd like to follow up on Professor Cohen's question. Your research deals with land. My understanding of the accusations of stealing of property rights of foreigners regards intellectual property. Do you see a distinction there? Is my impression a correct one?
Okay, that's great. That's my millions of project. One of my millions project.
Next project.
I don't have, again, I have to be cautious. I don't have the full picture. But what I can say is that I have been studying basically protection of music and also movie, the copyright of music and movie. You know, think about Disney, think about all these great American movies, right? They have, again, 1 billion audience in China, and many of them have been introduced to China. So what I have observed in this study is that on protection of copyright on China's internet in the last 20 years, it has been a 180-degree change. So 2000, in the early 2000s, when I was in college, everybody was watching all the great American movies, right? But we didn't pay. It's download from internet somewhere, and there were like big websites which were, again, steal all these movies and music and make money by allowing people to download for free, but they have advertisements. But now, actually, the data from 2018 is that 93% of the movie or the music on China's internet now actually is copyrighted and protected. And that's consistent with, again, our daily experience is now much more difficult. You can still do that to find a parodied movie or music online. So regarding that part of copyright protection or protection of intellectual property rights, I think that has improved a lot. And a long story short, the simple reason is that Chinese internet platforms such as Tencent, right? They are motivated to protect their license, which they got from Disney, from all these American, European suppliers, and they charge their users for that. But that's, again, just a very, very partial picture about high-tech I have no idea. So
I would add to that, as far as I know, there's been no country that has developed rapidly economically that hasn't stolen property rights, not land, but in copyright, patent. The US did that in the 19th century. When I lived in Taiwan in the 1960s, I could get every new book, every record for 10 cents on the dollar because they were all pirated. So it's true everywhere. So when a country gets rich, starts to produce copyrightable material itself, it starts to protect it. But I want to, unless Professor Zhan, do you want to comment on this?
So there are some other evidence in the economic sides that there are some institutional forms that are not directly to the intellectual property right protection, but has the implication on that. So one very important reform is that, so previously when those foreign firms, they enter into China, some industries, they have regulations on the form of the entry. For example, some like the car industry, they require you to form a joint venture. So you have to have a partner in the Chinese sides. And in 2017, they reformed the regulation that you don't have to. You can set a wholly owned firms in China. So in that, so that's why Musk he sent the firm in Shanghai. And in that form, if the firm is wholly owned by the parents in the foreign country, it's less likely to suffer from the so-called the stealing things. So I think there are reforms indicating a better protection of intellectual property rights. Yeah.
Okay, we're going to go now to Charles Guo, who has a question in the chat. I will read it because I'm not sure whether Judge Guo will be able to, just quicker. Hi, folks. I'm Charles Guo from the Chunzhou Intermediate People's Court. My question to you is that you might have overemphasized the impact and correlation of heavy workload to the increased winning rate of eminent domain cases by the plaintiffs. Mm-hmm. What about the limitation period of trials, which I take it to be, well, I'm not going to take it to be anything. What about the limitation of period of trials? It actually plays an essential role in impacting the decision of judges, particularly if they are under an overwhelming workload of cases. I believe, therefore, it is also an important element to consider in your research.
This is great, and thank you, Judge Guo, right? So if I understand it correctly, right, talking about the 限期结案, right? I mean, that's in the administrative litigation law, in basically every procedural law, civil litigation law, all right? You have to decide a case, first trial, like within 6 months, right? Second instance, like 3 months, etc. So there are limitations. I think that's not in conflict with our design or research, because if you have unlimited time, right, it does not matter how many cases you have. If you can decide 10,000 cases within the future 10 or 20 years, that's not a limit. Exactly because a judge has to decide a case within the limited period of time, then the workload actually matters. So I think that's basically my answer to this question. Basically to say that's part of the where the workload pressure comes from, because you have to decide a certain number of cases within a certain period.
Okay, so we also have a question from the executive director of USALI, Catherine Wilhelm. Catherine, please go ahead. I assume you can talk audibly.
Hi, thanks. Yeah, I wanted to just ask a question about what is happening with these cases outside of court. In other words, the study focuses on what the court's decision is, but I'm wondering what the plaintiff who has now won their administrative challenge, what have they actually won, right? Are they, if the court says that you're right, the government, the local government that took your property for a new road or a new shopping mall didn't follow the correct procedure. They skipped a step. They didn't get the right license. They didn't hold a hearing, whatever that step it may be. The court definitely has not been holding up the development for this case to be heard. We can presume that the development went ahead, the land was taken, the building was redeveloped, was taken. So what does the plaintiff actually win when they win this case? Are they able to monetize the victory in any way?
That's great. That's
I would just add to that. I had the similar question. Is there ever injunctive relief?
Yeah, great. We have seen the data. I think we should report it. So I think in a specific number, it's like 80 or 90%, 80 to 90% of the cases, the property clearly has been taken. So that's to say, when the case really go to court, it has already been too late to say protect the house or the land from being taken by the government. So we are really, all these cases, most of them, we are really talking about what happened after the government took your property, right? And that goes back to Catherine's point, right? Could they monetize, right, the decision? If you won a case in court, that's actually the main reason why they insisted on going to court, right, one level after another. Eventually, what they wanted is fair or just or even more or overcompensation, right? The more they go, the more pressure they impose on the government, and the more likely the government is willing to compromise to basically buy peace with money, right? So that's actually a very interesting point to think about the bigger picture, right? In our data, right? My previous article or this article, you say 93% of the cases, individual plaintiffs actually raised this claim of procedural mistakes, right? The government didn't hold a public hearing, etc. Only like I think 10 or 20%, they raised a claim of just a compensation. And even for that 20%, the court rarely supported the claim of just compensation. But we knew, right, in reality, what everybody was after actually was more compensation, was money. But that tells us, I guess, the different interactions and right, and also the connections between litigation and also what happened in reality. Right? Basically, they show they were trying to prove the government made a mistake in procedure, but for the purpose of after litigation to get more money from the government. So in other words, Catherine, you're right. They can monetize the result of the litigation.
John, do you have any additional comments? All right, well, let's just go to we have lots of questions here. One from Benjamin Chun, I will read it. What explains the increase in workload in some provinces, but not others? Yes, I had a similar question because of the lack of correlation between the economic status of the different provinces too. So I'm glad Benjamin Chun raised this. I'm just worried about whether treatment, which is not randomly assigned, is correlated with potential outcomes. For example, litigants are more likely to sue if they are more likely to win. This could be possible if local courts have signaled their willingness to take such cases. So either one of you, and I'm.
Tony, you want to take this question?
Yeah.
Okay.
So here, an interesting of this reform is that after the reform, the exception rule are unified across all provinces. So anyone who have a chance to win, and the potential benefit is higher for the fee, they will sue after the reform. So after the reform, the cases should be not different systematically across provinces, right? Anyone that have any small chances, they will sue. So what's important is the in the screening process in the pre-reform period, that some courts might screen the cases that to the right side, or some courts will screen some cases that are more difficult. So what's important is the pre-reform, the criterion before the law revision. So that's how we deal with that. So if the courts, they screen the cases differently before the reform, then we should see that they will have different cases enter into the courts, and they might have different characteristics, and they might have different adjudication results. But in the parallel trends, we have found that no, we do not find this systematic differences. In the pre-reform, they are very comparable in the adjudication results. And also we can see if other important characteristics, like almost all the cases will raise the procedure mistakes. So it's not about so we think that this will justify. It seems that the cases are not systematically different and in the pre-reform period.
Do you have anything to add to that, or should we go on to the next question? We have a few questions left. We have quite a few.
I think we should go on to the next, but thanks, Ben. He is actually a colleague at the University of Hong Kong, a rising star. So, yeah.
Well, it's good to have rising stars come to the webinars. Kuli writes the following question. Speaking of rising stars, thank you for sharing your research. This is really interesting. I just read Sun Ying and Fu Hualing's article on the judicial quota system, judicial quota reform of 2014 and 2017, which effectively disqualified about 90,000 Chinese judges. It sounds like a big number to me, but of course, China is a big legal system. Can you talk about how this reform may have affected judges' workload? In your research, when measuring changes in workload, are you able to control the changes in the number of, quote, frontline judges handling administrative litigation?
Thanks, Kerr, for the wonderful question. This is something we have been thinking a lot, and I think we have addressed that. What we did is that we have spent so much time collecting and coding data. How we define the number of judges is that actually we got all the names of the judges from over 30,000 administrative litigation decisions available at the Chinese judgments online from 2014 to 2017. Our definition of frontline judges is whoever his name or her name is actually on the judicial decisions, not the judicial decisions of expropriation, but all the administrative litigation decisions from 2014 to 2017. Then we calculate the workload as the number of judgments issued by like per judge per month. So I think with that, we have a quite accurate calculation of the workload of judges, actually even considering the impact of the the judge quota system, because we have the real number of average workload per judge per month. So that's how we control it. But I'll see whether Zhan Chaoqun has anything to add.
Yeah, so I have one point to add, that we are comparing the differences between across courts belonging to different groups. And so if the reforms are not systematically correlated with our classification, it will not confound our results. And actually, the judicial reform, quota reform in 2014, they have 7 pioneering provinces. And I've checked that 3 of them belongs to our treatment group and 4 of them belongs to our control group. So it doesn't seem that it's systematically correlated with the increase of the workload.
You were very fortunate with that breakdown of the ones that were in the control group and were not in the control group. That's great. Congratulations. We have a couple more. We have several more questions. I think we have a chance for two. This is from Winnie He. Your study is very interesting. You mentioned the courts did not, and the reason I'm choosing this one is that it's also, I have basically the same question. You mentioned the courts did not add new judges when the workload got higher. Was there any effort to give judges additional training or additional background to handle these cases or other kinds of cases which might improve efficiency? So I wanted to add a similar question, and that is, assuming, and this may be incorrect, but assuming that the plaintiff's high winning rate is not welcome politically to district level and county level officials, why wouldn't there be more judges? So I understand from the very beginning, Shitong said, more judges not likely. And I took that to be, oh, judges cost money, we don't want more judges. But if the insufficient number of judges is leading to decisions against local authorities, that costs the local authorities and the government money. So why wouldn't the government, and I realize that there are many levels, there are geographical issues, separation, so you can't just say the government, but I'm going to say it anyway. Why wouldn't the government say, oh, we can, one, save money by hiring more judges, and two, protect the political interests of our district and county level officials? So that's both mine and I've lost the Winnie He's question.
Yeah, that's great, and thank you. Firstly, I think it is indeed important to distinguish, make a distinction among different levels of government. Here in our data set is the high people's courts at the provincial level, which lower governments, county or city government, they have no control over the personnel of the high people's courts. And by the way, as our peers in the audience would point out that since 2014, there have also been this kind of reform about basically all the courts, their personnel and finance, according to the central government, are going to be directly controlled by the provincial level government. But I have not done study about how well or how comprehensive that study has been. So that means, yeah, local governments, they would have incentives to manipulate the budget, the personnel, but that's not present in our data. And for higher government, the provincial level, or even the central government, it's actually totally consistent with their interest to control, to discipline local government officials. So in other words, they don't have incentive to do what the local governments would want them to do. And that's actually also related to, again, my previous research is that when these judges, they choose administrative procedures, use administrative procedures to review the expropriation decisions. That's, again, totally consistent with the intention of the central government, because on one hand, it disciplines local government, right? You guys should do what the central government has asked you to do or how to do it, right? On the other hand, it's not like a particularly intervening in the eminent domain decisions, because it's not going to second guess what a public interest is, which is defined by the county or city governments, which takes property. So it's kind of a middle ground, kind of also politically safe to do that, or politically correct to do that in the Chinese context.
Let me follow up, Shitong, because it seems to me the premise here is that these decisions, these pro-plaintiff decisions, are correct. In other words, the district level officials have not followed the administrative regulations. And therefore, it is in the central government's, the provincial government's interest to make the district level officials follow the correct procedures. Is that the case? I mean, okay. It was implied that the judges just got really, really busy and they just threw them out whether or not the administrative proceedings had been followed or not.
That's a great question. The answer is yes and no. No, in the sense that we don't know. We don't know. We don't have a baseline, right? That's data or my just poor skills. We don't have a baseline to say how the case should be decided. Then we compare the real results to how the decisions should be made. So we don't have that. When I said correct, I meant politically correct. I meant it was consistent. It is consistent with the central government's institutional design to actually to have the high people's courts to focus on administrative procedures rather than other parts of the eminent domain. So I'm sorry, I don't have that skills. So
that's right. Well, you don't have the data. Chaoqun, do you want to add your perspective from a non-legal, empirical, economic analysis point of view, and also a point of view of within China?
So I have discussed with Shitong on this, like what are the counterfactuals that we're really interested in. So whether the cases are actually how the cases should be judged. Actually, we do not know, so we do not take a stand. I agree with Shitong on that. That's one point we have discussed for a long time ago. Yeah.
I also want to just add quickly, I think when you was asking about whether there are like additional training, whether they could add more judges. When I say like more judges, unlikely, I'm just talking about resource constraints. And as Nika pointed out earlier, the number of judges actually has decreased rather than increased. It's just extremely difficult to add more judges. And the quality of judges, I think that's a very nice point, right? Additional training or the 原额制改革, right? Judge quota system is supposed to improve the quality and support the judges receive. So that could potentially increase the quality of decision making. So we have not controlled that, but for I think a justifiable reason, that's to say within like basically within 2 years, we don't think the quality of decision making would improve a lot to impact our results, but I could be wrong. We should probably check that. So, yeah.
So we have one more question that is also relevant to what's happening right now. And actually, USALI is considering perhaps having a program on this question. And that question is the lockdown in Shanghai over COVID. And this question comes from Sylvia Schur. And it is about the question of whether people could sue the government, specifically mentioning Shanghai with the administrative litigation law for claiming for compensation as a result of the government entering people's property and forcing people who tested positive to move to special COVID treatment hospitals.
Okay, that's a great question. I would say that goes to, again, our last point about how power actually overrides law, right? When the power is really insistent and also of higher authority. So unfortunately, in China right now, I don't think there's any compensation. I doubt whether such cases could even go to court in Shanghai right now or even afterwards. So that's, again, we are talking about the so-called improvement in a very confined zone. So, yeah.
Well, I want to thank both our speakers, and these are extremely, the question of whether power affects legal decisions is not limited to China. And as Shitong brought up at the very beginning, with comparison to many other different places, it's a question that we will always be able to return to. And again, please tune in next week, not exactly the same time, but also on Wednesday for a discussion on the impact of the pandemic on the WTO. And keep in mind, keep your eye out for a possible USALI event on Shanghai and the lockdown there. And thank you all for attending.